Janet Gongola. Ms. Gongola has been on the road quite a bit. If you haven't noticed, the PTO outreach on the proposed rules has been very extensive, and I feel a bit sorry for her having to live out a suitcase. For those of you that aren't aware, IEEE, USA's Intellectual Property Policy Committee's had some pretty substantial filings and comments on the proposed rule packages. We've had a small subcommittee that's worked very hard. Very difficult challenge. PTO has been very responsive. For that I commend, because a lot of questions are being asked that are very difficult to deal with. And again, we very much appreciate Ms. Gongola's participation. Thank you.
Good afternoon, everyone. Can you hear me okay? How's the web audience? Can you hear me okay as well? How about now? Is that better? Okay, good. Well, thank you very much to Keith Greslock, and I might be mispronouncing his last name, for which I apologize. Oh, I think I got it right. As well as Erica Wozlak, and I might be mispronouncing that as well, for inviting me to participate today in the program about the America Invents Act. Obviously, my favorite topic of late. I also appreciate the chance to come back and update you on the progress that the agency has made in terms of implementing the AIA since I appeared here last year. So it's always a pleasure. Now, you probably are aware from my conversation with you last year that President Obama signed the America Invents Act into law with certain objectives in mind. He wanted to modernize the U.S. patent system. He wanted to reduce the backlog of application that stood in an unexamined state. At the time when the America Invents Act was signed into law in September of 2011, the backlog stood around 700,000 applications. Today, the backlog has been reduced around 650,000 applications, but still at an unacceptable level, and further work is needed. Additionally, President Obama sought to spur the economy and create U.S. jobs. And for those of you who have been watching the debates as of late, to both sides, you will understand that job creation and the economy is significantly important in the United States. Now, for those of you who might be wondering about the connection between intellectual property and our economy, the Patent Office, in collaboration with the Department of Commerce, conducted a study into the role that intellectual property plays in the U.S. economy. We found that 40 million jobs are tied to IP-intensive industries, and that wages are 42% higher in IP-intensive industries. Further, we found that over $5 trillion of the gross domestic product and more than $700 billion in U.S. exports originate from IP-intensive industries. So hopefully those stats will convince the non-believers out there, to the extent there are any, in the criticality of IP to building our economy and fostering job creation in the United States. Now, I'm sorry, I'm not sure what that slide is. The slide is meant to show, oh, you can't even see it very well. What this slide is intended to show you is a breakdown on a state-by-state basis of the contributions that that state makes to the economy in terms of IP-intensive jobs. So for those of you who have the handouts, you can see that there's a range going from upwards of 5% to the low end of less than 3% of U.S. jobs being tied to IP-intensive industries. Okay, now our AIA report card. Last year when I came, I talked about those provisions that went into effect on September 16th of 2011 or within the couple months thereafter. This year, I want to focus on provisions that went into effect on September 16th of this year, a month ago. And those are listed for you in the first column on this slide. And in particular today, I'm going to talk about the inventor's oath or declaration provision, supplemental examination, and the citation of patent owner claim scope statements. And I know other speakers throughout the day have covered the remaining provisions. Now, before we roll up our sleeves and go into detail about those 3 provisions, I also want to point out that certain provisions are going to go into effect next year. Those have been mentioned already today. The first is the first inventor to file provision. That provision becomes effective on March 16th of 2013. And as prior speakers have mentioned, the agency right now is in the process of collecting public comments. So the second row of the slide lists for you the 2 email addresses that you can use to submit your comments to the agency. As well, we have extended the first inventor to file comment period, which originally closed on October 5th, and we're now moving it out by 1 month until, it closed October 5th, moving it out until November 5th. And then second, we are in the process of setting or adjusting our patent service fees. And our comment period on our fee setting will close also on November 5th with email addresses for submitting comments there. So I genuinely encourage you to please consider giving us your feedback. Throughout the agency's implementation efforts, we believe that we are charged with collaborating with the entire IP community, all segments, to hear their views, incorporate their views, and try to produce a balanced set of final rules to implement the Act. So we need you to tell us where we've gotten things right, where we need to make modification, and where we have to go back to the drawing board and begin again. And as you'll see in a moment, we've taken all of the feedback received to date into account as we've built final rules for provisions in that first column. And specifically, focusing just on the patent-related provisions, which is the first pie chart on the left side, we collected 123 written comments. And on the slide, you can see the distribution of who submitted those comments to the agency. We carefully considered each one and incorporated many of them into our final rules. I mean, most notably, our inventor's oath or declaration provision was, I would say, almost a 180-degree change from what we proposed, all based upon the feedback we collected from you. Throughout, you'll see on the slides, there are certain sentences or phrases that I've placed in italics. Now, I'm not going to single them out as I go through, but as you're looking at the slides, you'll know that those are aspects of our rules that we changed in response to the public comments we received from all of you. Now let's talk about inventor's oath or declaration in much more detail. This provision has the big picture aspect of simplifying the statements required for an inventor's oath or declaration to make it easier for an inventor to file an oath or declaration. It likewise simplifies the process for filing a substitute statement, and it extends the time period for submitting an oath or declaration to the agency. The time extension is aimed at recognizing the realities of modern day business, where inventors may be located across the globe. They no longer may be working in a single state, in a single city, in a single research laboratory. So oftentimes it's difficult to gather the inventors together to have them execute the oath or declarations. So now the America Invents Act is giving more time for an oath or declaration to be executed and submitted to the agency. And then lastly, the inventor's oath or declaration provision allows assignees, obligated assignees, and persons who have a sufficient proprietary interest in an application to make a patent filing and protect the intellectual property in lieu of an inventor. But as you'll find out, this doesn't mean that inventors will be cut out of the process. Inventors will still be integrally involved in the application process. They just might not have to monitor each step of the way as they have done in the past. Now, it was mentioned earlier, this provision went into effect on September 16th, and it applies to all utility, design, plant, and reissue applications filed on or after that date. And the previous speaker explained the filing date is what's key for knowing whether you must supply an old-style pre-AIA declaration or a new AIA type of declaration. So if you file an application today, you're required to file a AIA-style inventor's oath or declaration. Now, if you filed your application before September 16th, you didn't include an oath or declaration, you received a notice of missing parts, you can file in that pre-September 16th filed application an old pre-AIA type of declaration. Another situation. For a PCT filing that was filed before September 16th and is being nationalized after September 16th, the filing date of the international application controls. So you would file a pre-AIA type declaration in that case. And then the last scenario is a child application that's filed after September 16th. You must file an AIA-style declaration in that child. You're not entitled to go back to the priority date of the parent for purposes of judging what type of oath or declaration to file. You filed the child after the 16th, so you must adhere to AIA law. Okay, now let's get into the amendments made by the AIA to Section 118 of Title 35. This is the provision that expands who may file an application as the applicant. It includes assignees, obligated assignees, people to whom there's an obligation to assign, and lastly, persons who have a sufficient proprietary interest in the application. So going forward, the term applicant no longer is synonymous with an inventor. It may very well mean one of those three categories of entities. But as I said, inventors will still be involved in the application process. They still must be named. And there's two ways that that can happen. The first is through an oath or declaration. And you'll note that I've put the words oath or declaration on the slides in quotation marks. I'm meaning to signify, as we'll get to on the next slide, the term oath or declaration here could be used to mean a traditional style oath or declaration. It likewise could mean a substitute statement or an assignment containing the statements required for an oath or declaration. And we'll talk about that next. Alternative to our quote, inventor's oath or declaration, an inventor also could be named in an application data sheet. We'll talk about it in more detail as well. Okay, so the amendments to Section 115 of Title 35 provide for the naming of an inventor through a traditional style oath or declaration, a substitute statement, or one of these combination assignment oaths. Now let's focus on the traditional style oath or declaration. The AIA is simplifying the legal requirements for what type of information that an inventor needs to attest to in the oath or declaration. Under the AIA, the inventor only has to make 2 statements instead of 4 under pre-AIA law. The 2 statements are that the inventor is an original inventor of the claimed subject matter. Additionally, the inventor has to attest that they, authorized the application to be filed. Now, those are 2 statutory requirements, and the agency has added on 2 additional regulatory requirements. The inventor has to identify the application for which the oath or declaration is being submitted, and the inventor has to also provide his full legal name. Now, for a substitute statement, a non-inventor may file a substitute statement when an inventor is not available for 4 specific reasons. They're listed on the slide. The inventor is deceased, legally incapacitated, cannot be located after a diligent effort, or they're recalcitrant and they simply refuse to sign the oath or declaration. Now, this non-inventor is limited, and the three types of entities that can qualify to submit a substitute statement should sound familiar. They may be an assignee, an obligated assignee, or a person who has a sufficient proprietary interest in the application. By circumscribing the number of entities that might file a substitute statement, the AIA is preventing someone from sidestepping the inventor. Remember, the key here is, even though assignees can be applicants, and even though a non-inventor might file, we don't want to totally exclude an inventor from the application process when they are available. Additionally, when an assignee or an obligated assignee wants to make one of the substitute statements due to the unavailability of the inventor, these two types do not have to provide a petition to the office. However, a person with a sufficient proprietary interest must still petition the office and provide a demonstration of their ownership interest. This is going to prevent anyone from coming off the street saying they have an interest and filing the substitute statement. They have to provide an evidentiary showing of their ownership interest in the application before they can make a substitute statement. Further, this non-inventor has to provide certain information in the substitute statement. They have to identify themselves and their relationship to the inventor. They likewise have to identify which one of the four circumstances entitles them to file the substitute statement. Was the inventor deceased, legally incapacitated, not available after diligent effort, or refused to sign? And for those last two categories, under the AIA, the non-inventor does not have to offer up proof of all the steps they did to try to locate the inventor or convince the inventor to sign the oath or declaration. Additionally, the non-inventor has to identify who is the original inventor of the claimed subject matter and attest that this person invented it. Make the statements, in other words, required for an inventor's oath or declaration. Now, the third option is for the statements required for the oath or declaration to be included in an assignment document. So this assignment would serve a dual purpose. It would provide the oath or declaration and at the same time identify who the owner of the application is. The key here is that the assignment has to be recorded in the patent office to serve this dual function. Further, to avoid a surcharge in not submitting the oath or declaration with the application, it is a best practice to file the assignment document on the same day as the application. And when you're doing that, whether you're filing by paper or I would encourage filing electronically, you want to make a definitive indication on the cover sheet of the assignment that you, as the applicant, want it to serve this dual function. That way, the office will take the assignment, whether it's filed with the application, they'll send it to the assignment branch, or whether filed in the assignment branch, they'll send it over into the application file. Now, for these three different types of documents, the AIA is eliminating certain statements of information that must be provided. An inventor no longer in a single declaration has to list all of the names of the inventors if there are more than one inventor and have all of the inventors execute a single declaration. As someone mentioned, each inventor can now execute their own declarations. Further, an inventor no longer has to provide their country of citizenship or state that they are a first inventor. Now, the requirement to be a first inventor derives itself from the first to invent system for priority to a patent that we are currently under until March 16th. Now, in this intervening period of time from September until March 16th, Well, we are still under a first to invent system, but the law is eliminating the requirement for the inventor to make that first statement in this 5-month period. Let's see, what else? The last thing, an inventor no longer has to make a foreign priority claim in the oath or declaration. In fact, the foreign priority claims and domestic benefit claims both must be present in the application data sheet for the office to acknowledge them and recognize them. We are centralizing the location of the foreign priority and domestic benefit information to the application data sheet so those in the receiving office at the PTO know where to quickly find that application, can enter the relevant information into the application file. They will no longer have to look to multiple documents, the oath or dec for foreign priority and the application itself for the domestic benefit claims. An additional eliminated requirement is that the inventor no longer has to state that they acknowledge the duty of disclosure and they were aware and understand, they've reviewed and understand the contents of the application before they executed the declaration. Now, the elimination of this duty of disclosure statement does not mean that the inventor is no longer under the duty of disclosure. The duty of disclosure still applies to the inventor and anyone connected with the patent application filing, just as it always has done. The AIA eliminates the duty of candor requirement throughout Title 35. And so for consistency, the statement is no longer required in an oath or declaration. But I want to emphasize inventors are still under the duty of disclosure to the Patent Office whenever they file a patent application at the PTO. Okay, now, we have provided, as it's also been mentioned, forms on our website. The first bullet provides the address. We have oath or declaration forms, power of attorney forms, substitute statement forms that you can download and use. We likewise have created a user guide. So if you forget everything that I tell you today about executing an oath or declaration, a substitute statement, or a dual assignment and statement, you can look at the user guide and it will walk you through exactly what you need to file with the office to have a compliant oath or declaration. The one thing we do not provide forms for is the dual assignment statement. And the reason for that is because assignments are a matter of state law. So we're not going to provide 50 different possible assignments that state courts may recognize. We leave that up to the applicants and the circumstances of different employment agreements to govern. Lastly, on the timing of a submission, an inventor or the applicant can now wait to submit the oath or declaration until the office issues a notice of allowability. This delay, though, is contingent upon the applicant submitting an application data sheet naming all of the inventors with their mailing address and their residency at the start of prosecution when you file the application. The Patent Office still needs to know who the inventors are before we begin examination so that we may apply the correct prior art. We likewise may assess for double patenting. And we will obtain that information off of the application data sheet. Now, if you like, an inventor could still choose to file the oath or declaration with the application. They likewise could piecemeal it throughout prosecution. The key is we must have the oaths or declarations for all inventors at the conclusion of the 2-month window after a notice of allowability to be able to issue the patent. Oh, and if you forget to file your oath or declaration, I should mention this too. There is a $120 surcharge that you will be required to pay. Okay, now, so we're clear on the role of the application data sheet. It serves a couple different functions. It provides a listing of all of the inventors so that the Patent Office can do our examination properly. It likewise houses all of the domestic benefit and foreign priority claims. So even if you are filing the oaths or declarations with the application, it still is a best practice to submit the application data sheet to the office. Not a requirement, but a best practice. We have application data sheet forms available on our website as well. I'm going to skip the pre-issuance submission because the next presenter is going to cover it in detail. So I'll move to talking about supplemental examination. This provision also became effective on September 16th, and it's available for any patent that is enforceable. A patent is enforceable for the period of 6 years after the expiration date. So we could, theoretically, conduct a supplemental examination on an expired patent for the 6-year window after the expiration date. Now, what a supplemental examination does is allow the patent owner, and only the patent owner, to come back to the office and seek consideration, reconsideration, or correction of information believed to be relevant to the patentability of the claimed invention. The information is not limited to a patent or a printed publication. The information may be directed to any of the conditions for patentability, from patent-eligible subject matter under Section 101 through indefiniteness and best mode under Section 112 and everything in between. The Patent Office is restricting the number of items of information in a single request for supplemental examination to 12 items. How did we arrive at 12? Well, we went back and we looked at requests for re-examination, and we found that above 90% of all requests for re-examination involve the submission of fewer than 12 items of information. So that's how we arrived at the number, because we believe 12 will cover the vast majority of all scenarios out there for which, the number of items of information a patent owner may want to submit for the office to consider, reconsider, or correct. Now, if a particular patent owner needs more than 12 items, they will need to file multiple requests for supplemental examination, and they can do so in parallel. To file a request, a patent owner can do so electronically or by mail. They simply cannot file by facsimile. When they make the filing, paper or electronic, the best practice here is to include a transmittal cover sheet on the submission, indicating that it's a request for supplemental examination. That way, when it's coming into a patent filing, the office will recognize this is a paper that needs quick action, because the office has a 3-month window to make a decision on a supplemental examination request. The submission will not be confused with a prior art submission or a citation of a patent owner claim scope statement, which we'll talk about next, which the office is not going to address immediately. So you want to flag your supplemental examination request to be sure that the office considers it in that 3-month window. We have a form, a transmittal cover form, on our website that you can use to make it abundantly clear to the office what your submission is. Now, this slide lists for you the contents of a request for supplemental examination. The patent owner must identify the patent and the specific claims for which supplemental examination is requested. The patent owner likewise must tell us what items of information are to be applied to each claim on a claim-by-claim basis. And the patent owner has to explain the relevance of applying these these items of information to the claims. If a particular item of information is more than 50 pages in length, the patent owner has to offer up a summary of that document. The reason we need a summary is the Patent Office has only 3 months, so examiners need your help in focusing their review of these items of information to only that portion of the item that bears upon the patentability of the claimed invention. But there is no restriction here on the request itself being size limited. It can exceed 50 pages. And lastly, there are some fees that will be required. We'll talk about the fees next. The request for a supplemental examination will cost $5,100. If the office orders a re-exam to follow from that supplemental exam, the cost of the re-exam is $16,000 for a total of around $22,000. How did we arrive at this number? The Patent Office presently, and for our final rules that just went into effect in September, we are required under Section 41D of Title 35 to set fees at cost recovery for a service. So we assessed what we expected a supplemental examination to cost the agency. It's bifurcated into 2 phases, and that's how we priced it. Going forward, when we set our fees using the AIA, the Patent Office is not restricted to setting fees for cost recovery. So if you look at our proposed fees for supplemental examination that's subject to comment right now, you'll see that we've reduced the cost of supplemental examination around 30%. We also are staging the fees so that a patent owner pays the first fee for the request for supplemental examination at the time they make the request. And then, if the re-examination is ordered, we are proposing they would pay the follow-on fee for the re-examination phase. So it's going to break down the time periods plus reduce the cost under a proposal. Right now, though, the full $22,000 is due upon filing of the request for supplemental examination. Was there a question? Was there a question? I saw you had your hand, someone had their hand raised.
And consider the effect of the Independent Offices Appropriations Act requirement for cost recovery.
I'm sorry, I didn't quite hear everything that you said. Did we consider the...
Did you consider the effect of the Independent Offices Appropriations Act on requirements for cost recovery?
I'm sorry, I don't know the answer to that question. I would have to talk to our finance folks to find out, but I'm happy to collect your card and follow up with you after the fact to get you the answer to that question. Yes, sir. Another question.
I guess the comment period ends.
I don't think it's on, but I can hear you okay.
The comment period ends November 5th, is it?
Correct. For the proposed fees.
Oh, okay. And I was wondering, has anybody commented regarding payment plans for small inventors and micro entities?
I'm not through all of the comments received to date, so I don't know if we've received such a comment. But if that's an idea that I haven't heard before, and I would encourage you to submit it to the office. And I mean, you know, when you're submitting these comments, they don't have to be super formal. I mean, they can be a mere email that's 2-3 sentences. They don't have to be a law review style comment. So we welcome any form of comment. So that's a great idea. You should submit that.
Thank you.
Yeah, you should submit it to the agency. Do you have any other questions? Yes, sir.
I have a question regarding the patent term adjustment for applications. There's a suggestion that the office will reconsider the delay in filing a declaration after the issuance of allowability regarding the term adjustment of that, that's understandable. However, the office also issues a filing receipt and a notice that a declaration is due. There's a requirement
I don't know the answer to your question, but again, I'd be glad to take your card and have follow-up discussion with you about it. I'm sorry I can't answer you today. Yes, sir.
I have a question about supplemental examination. Does the duty of disclosure exist during the period when supplemental examination is requested?
Yes, the duty of disclosure exists whenever an applicant or the patent owner is coming before the office with a filing. In fact, in a supplemental examination, there is a provision that goes beyond just the duty of disclosure and requires the office to turn over a patent owner who may have committed a material fraud in connection with a patent application undergoing the supplemental exam to the Attorney General. And then that could lead to criminal prosecution. Now, having said that, though, I don't want you to panic. The Patent Office is, first of all, we view material fraud to be an extremely high standard. It is much more difficult to prove a material fraud than an inequitable conduct. And second, we're not planning on reviving our fraud squad to be out there rooting around trying to determine cases of fraud. But the duty of disclosure does attach during a supplemental examination.
So one might be committing fraud on the patent office if one receives a U.S. patent the following day of office action issues for the patent office with new references.
After the patent is issued, if you've issued the patent's issued to you, there's no obligation on you to come back in for a supplemental examination with that new information. And I'm not going to say that's committing a material fraud. Fraud has multiple elements, and one of those elements is a mental state. And so we would have to know more about the facts in your hypothetical to be able to judge, and as well as the four other elements to know if that's a material fraud.
Well, I'm not worried about material fraud. It would be a ground for attacking the patent. The day after your U.S. patent issued, you were in prior art, and you didn't spend $5,000 to seek supplemental examination.
Well, the prior art that's come out after your patent issues could certainly be used by an accused infringer, or you probably learned this morning, a third party could raise that art through one of the administrative trials, a post-grant review or an inter-parties review. So it might be a basis to invalidate your patent. I'm not going to say that it would be a basis to attack the patent as being unenforceable for inequitable conduct. Need to know more. But this piece of prior art could certainly be used to try to challenge the patent as being invalid under anticipation or obviousness, probably pretty certainly. Yes, sir?
I think you guys might be talking past each other. I think what he's asking is whether the duty exists in between the period from when the patent issues to the point where you may or may not file a supplemental examination. If you haven't already filed one, there is no duty in the intervening period.
Correct.
Yeah.
Correct. And if I'm sorry if I misunderstood your question. Whenever you're in front of the office, there is a duty. So that would be during the prosecution of the application that led to the patent, and it would be during a supplemental examination or any one of the administrative trials, or a re-exam or a reissue.
Our microphone ran out of battery, so can it just...
Oh, you want me to repeat the questions?
Or don't take questions till we're back with a battery.
Oh, okay.
Either way.
Okay. Well, how about we've had a battery issue with the microphone, so to make sure our web audience can hear everything, we're not going to take any more questions now. I'll return to the presentation, and then when the battery is back, we can start the questions again. Okay, so now when a patent owner files a request for supplemental examination, the office is going to look at the request and determine whether it is compliant with the requirements. Is it filed at the right time period, etc. Now, if it is compliant, the Patent Office will place it into the patent file and it will be made public. If the request is not compliant, the Patent Office will alert the patent owner of the defect and give the patent owner an opportunity for cure. We will not, though, make the filing public, because what we don't want to have happen is a third party, a putative accused infringer, C, the items of information that the patent owner is asking the patent office to consider, reconsider, or correct, and then seize upon those items and run off to the courts and bring a challenge that the patent is invalid or that inequitable conduct was committed and therefore the patent is unenforceable. So if a patent owner files a non-compliant request, there's a certain time period that that request will be protected. If the patent owner never cures, we're going to discard the request. It will never be part of the patent file. If the patent owner does cure, we will treat the filing date as the date that the compliance was made, and we will then place that compliant request into the patent file for the public to view. The standard. To trigger a supplemental examination, the patent owner must show that a particular item of information raises a substantial new question of patentability. This should sound familiar. This is the standard that the Patent Office uses in re-examinations. So you could check out the MPEP for more information on the standard. In general, the standard is means whether a reasonable examiner would consider the information important to the patentability of the claimed invention. With re-exams, that standard has been used in the context of patents in printed publications under anticipation or obviousness. Now the standard is also going to be used to address questions of patent-eligible subject matter under 101, written description, enablement, best mode, indefiniteness under 112. So you'll have to keep an eye how the office maneuvers the standard in those additional circumstances. We'll have to hold for your question. I don't think the microphone is back yet, but you'll definitely get a chance to answer it. Oh, is it back?
Sorry about that. The facility's traveling mic, the battery died, so I went to the bowels of the building and I found the battery. so
if
we're all
it's
set
working,
here.
we do have a question here.
So my question relates to the fees. Say the office declares...
It's about fees?
About fees,
Okay.
yes. There's two fees. One is the fee to file the request. The other one's the fee for declared re-examination, correct?
Correct.
So there's two fees. The first fee is about $5,000. The second fee is about $16,000.
Yes.
So say I file such a request on behalf of my client, and the office and the examiners receive it, and you note that, or they note that the office will get another $16,000 if they declare the re-examination. Now, most re-examinations are substantive and they go through with rejections, but some are declared because there's a substantial new question, and the first office action you get is there's no issues, all claims allowed, or closing prosecution. It seems to me that there's a built-in bias for the examiners to declare a re-examination and then issue an office action that says, well, by the way, we were wrong, all the claims are still patentable. But now the office is $21,000 richer instead of just $5,000 richer. So my question is, has the office considered, or did it consider in the rulemaking process, the impact of the fees on the examiner's mental state in considering whether to declare re-examination? And would it consider comments regarding refund of fees where the first office action indicates after declaration of the re-examination that all claims are in fact patentable and the office was right in the first instance?
Well, two things here. We set these fees under cost recovery. That's what we're obligated by statute to do. So whatever we expect a supplemental examination to cost, both the supplemental phase and any ensuing re-examination, that's the fee that we have to charge. Now, could we have examiners who have the intent of declaring the ex parte, finding a substantial new question and declaring an ex parte re-exam? It's possible, but I doubt that that is the single motivation behind an examiner's SNQ determination. Now, to the point about the refund, when we go forward, we're not going to refund, but we recognize it is a heavy burden to pick up and put out $22,000 at the outset and not get a refund if the supplemental is not declared. I should have said that, and if I wasn't clear on that, if we don't declare a supplemental examination, we're going to refund. I think that's next on the slide. So if we go through the process, we say that there is a substantial new question of patentability and the director orders a re-exam, we're going to keep the $16,000 for the re-exam. But if we go through, find that there is no item of information that raises a substantial new question, then we will not declare the ex parte re-exam and we will refund the $16,000. Now going forward, because we know it's a heavy lift to pay out the $22,000, we're staging the payments under our proposal. We'll see if we end up there based upon the public feedback, but we're staging it so that you only pay, it's 30% less than $5,000 for the request, 30% less than $16,000 for the re-exam if one happens to be ordered. So we are trying to offer some financial relief for these proceedings. These should be rare, though. You have to think about it. These proceedings are designed to immunize a patent against an inequitable conduct attack. So it shouldn't be an everyday course of business for a patent owner to have to come in and seek a supplemental examination. They should be thinking of coming in surgically based upon a particular reference that they learn about, that they have some concerns over. So we don't view supplemental examinations to be an everyday occurrence. In fact, to date, we've only had 2 supplemental examination requests filed since September 16th. So it does appear to be more of an anomalous type situation. Now this is the process so that you can see stepwise what will happen. The patent owner makes the request. Within 3 months, the Patent Office decides the request. We will determine each claim that's challenged based on each item of information raised, whether that SNQ standard is triggered. If it is, we'll go across the horizontal. Supplemental examination will conclude, and we will order ex parte re-examination. And then the ordinary rules for ex parte re-examination apply with a couple exceptions. The Patent Office will not require a patent owner statement. The reason being, we heard from the patent owner with the request. Additionally, what's the second one? I forget, there's one other exception that doesn't apply during the re-examination. I don't remember what the second one is, I'm sorry. And then down the vertical arrow, if no item of information triggered a substantial question of patentability, then the supplemental examination still concludes, but there is no follow-on re-examination. So I want to point out, either way we go, across the horizontal or the vertical, the supplemental will wrap up at the end of the 3-month period. It concludes by the office's issuance of a supplemental examination certificate in electronic form. That certificate stays in the patent file for its life, even if the re-exam follows and there is a re-exam certificate issued. The supplemental examination certificate will still stay in the file. The certificate will indicate for each challenged claim on each item of information whether the substantial new question of patentability standard was triggered. Now, the examiner won't have opportunity in the certificate for much elaboration, but if the examiner chooses to elaborate, then he can attach a separate document to the certificate listing out his reasoning. Okay. Oh, questions? Yes.
There were a couple of questions before the battery went out on the hand mic. Online, Brian had a question regarding assignments and declarations, and he asked, is the assignment declaration filed by EFS, EPAS, or both?
The combination assignment declaration is a best practice to file through EPAS. That's what I'd recommend doing. And when you make that filing through EPAS, you should indicate on the transmittal cover in very clear terms that you want the document to serve as the assignment and the oath declaration. That way the office sends the paper over to the application file as well. That's the easiest way to use a dual document.
Right, thank you. Karen also had a question. Assignments that are filed on the same day as the application causes the notice of recordation of the assignment not to have the filing date. Is this going to be remedied? Is this even a problem?
I don't believe that that is a problem. What should happen is if you're going to file your paper, your application, I again encourage you to do so through electronically EFS web. I mean, the reason you want to e-file too is because there's a $200 surcharge that attaches for paper filings that was brought about through the AIA. And the Patent Office doesn't keep that money. That goes to the General Treasury. So you don't want to have to pay any extra money when you make your filing. So it's best to do it through the electronic filing system, EFS Web. So what you do is you file the application on EFS Web, you get the application number, then later in the day you go into the ePass system, file your assignment, and you have the application number to reference on the assignment document so that there's a correlation between the assignment, serving this dual purpose, and the application.
Question also. Carlos has one more.
Oh,
Thank you.
yes, sir.
It's really not a question, it's more of a comment. I just filed an assignment yesterday, and I noticed there's a checkbox, which of course I didn't quite understand when I saw it, but it said you can check the box to use it as an oath and deck also. So the software has already been updated.
That's what it's for, yeah, to allow you to immediately indicate on the transmittal cover exactly what you want to do with this document. It's to make it easier for you.
Janet, I have a comment and then I believe 2 questions, if I can remember them all. So the comment is, in practice, with the new Inventor's Declaration, the new law for Inventor's Declarations, you can send each of multiple inventors a declaration, have them sign independently, and file those documents in the application file to complete the declaration requirements. You can also file an assignment in the assignment branch, record an assignment using an assignment form. The problem we run into in practice is an accounting problem. When we have multiple inventors and we get multiple papers back, somebody has to keep track of who the list of actual inventors are. And believe it or not, that's a real logistical problem at times. So the solution, and this is the comment, is in Archimine form, there is a list of inventors. You know, maybe we have separate signatures from each of 5 or 6 different inventors, but we have a list in the form, in the combined form, that lists them all. So that's the comment, that's a practice point. With respect to the checkbox, it's never been confirmed to me, although OPLA has sort of indicated this is the case, that if in fact you check the box in ePass, which says use this as the declaration, that you do not, and you file that on the same day as the application specification, that you do not thereafter have to pay the surcharge for a late filed declaration. First of all, can you confirm that to be the case?
That's correct.
Okay. Not that we would do that, because there's no sense, if you have the combined form signed, not to file it into the IFW when you are filing the application.
Right, if you file them on the same day, you file the application electronically and you file the assignment serving a dual purpose, check the box, then you will not be assessed the $120 surcharge.
Thank you. We would, of course, we would check the box, but we would also, as a best practice, file the declaration assignment form in the IFW directly, in addition to filing requests for
Right, you're welcome to do that.
Just to let you know, that would be the best
You're
practice.
welcome to file the assignment in the assignment ePass system. You could also duplicate it in the application file to ensure that the office considers it. The reason that we went to allowing the ePass file to send it over is to try to help inventors from submitting so much paper to the office, make it easier, lessen the burden. But if there's concern, you can certainly file in both places.
The reason why it's a best practice is you fill in the application number manually in ePass, and it's not automatically transferred both ways, so you can actually put in the wrong number. That's why filing the inventor declaration form in the IFW directly is a best practice. But my questions are, with respect to the previous process, the post-grant submissions, the ones where you file a request to see whether re-examination must be declared, and with respect to the pre-issuance submissions, you file as a third party information, printed publications, and a concise statement of relevance. Both of those filings do not go directly into the IFW. They're not publicly available. There's a separate cubbyhole that the PTO is using to in-camera inspect them. I'd like to know what the name of that cubbyhole is. What's the process for the software or the service inside the PTO that's used to perform that practice, the in-camera storage and review before release to the IFW? What name do you give it?
So let me understand your question. You would like to know when a third party files a post-grant review petition, or separately when a third party files a pre-issuance submission?
No, not a post-grant review, not a IPR or PGR or CBM or DER. When a patent owner files a post-issuance request to have the patent reviewed and perhaps have a re-examination declared if there is a substantial new question, that filing is not immediately available in the patent's IFW, correct?
I don't know about re-examinations. I can talk to you about pre-issuance submissions and what happens there.
And the post-issuance submission also, supplemental examination.
A supplemental, I don't know
just-
the name of it. Okay, so for what happens, let's break it down and do each separately. For a pre-issuance submission, what happens is the office receives it. A TQuas that's in the Technology Center, that's the subject of the application, will review the submission to make sure it's compliant with the statute and the rules. Is it timely filed? Does it contain the concise description of relevance? Is the concise description of relevance compliant, etc.? Once it's determined that the application, the pre-issuance submission is compliant, then the submission will be entered into the EDAN or the PAIR system,
The IFW.
the IFW system, and it'll be placed on the examiner's IDS tab for the examiner to consider.
Understood. But there is a filing. We file either of these types of submissions electronically.
You file an EFS web.
Yes. And the documents received by the Patent Office, but it does not appear in the IFW. In what system is it stored?
I don't know the answer. I assume it's EFS web. We don't have some secret system that we're not giving the public access to.
Well, the papers are by rule not made publicly available until you complete
Correct.
the
We must
review.
determine compliance first.
So,
And if they're not compliant, they'll never be publicly available. They'll be discarded. And if they are compliant, then they will be made publicly available in the
So-
application file.
So I guess the take-home question is if you could let us know what the PTO calls the system in which the papers are received by the Patent Office when filed using EFS web.
Sure, I'll be glad to investigate it. I'm not positive there is some separate system. I don't know. We'll have to look into it for you.
Thank you.
I think there's a question
Yeah,
right
one
behind.
more question back here.
Yes, Janet. In the flow chart you had up a few moments ago, I just want to clarify whether the ex parte reexamination fee is the same $16,000 of the supplemental examination fee, or if that's an additional.
No, okay, so the $5,000 for supplemental buys you the decision that's in the green triangle.
Right.
Okay? And then the $16,000 for the ex parte re-exam buys you something that's not even shown on this diagram. It's
Right.
the step that's going to follow after the blue circle. If the office declares an ex parte re-examination, then the $16,000 is what pays for that ex parte re-examination.
Right. That's just what I wanted to confirm. All right. Thank
Yeah,
you.
and that is not, the ex parte re-exam is not shown on that flow diagram. Other questions?
This is a quick question that my firm has run into. I was just asked the other day by a partner in my firm, because of the oath declaration changes, now it's possible for the company that has the rights to the invention to file things on behalf of inventors. And the issue that we were running into was that, as it was told to me, the company is a foreign company, like a French company or something. And apparently that was creating an issue where if it wasn't in the United States, it wasn't able to, serve in that role as the applicant. Is that right? And is there any loophole or way to get around that?
Well, the assignee can be a US-based company or a foreign-based company. So in your fact pattern, if the assignee is a foreign company, they could file an application, but they're still going to have to name the inventors and file the inventor's oath or declaration in the application, or, if appropriate, the substitute statement or the dual-purpose assignment statement document. They can be an applicant. Foreign applicants apply all of the time.
Okay, so the person who said that was a problem is just wrong, and they need to explain that to them, that the foreign company can file it.
on the limited facts you're telling
Right,
me.
right,
Maybe
right.
there's some other facts I don't know about, but the way
I think that's it, though. I
the
think you got
basic
it.
scenario, a foreign entity can be an assignee applicant.
The issue likely comes up with the international application. If you try to use the U.S. receiving office and you don't have an applicant who is a resident or national of the United States of America, the U.S. receiving office is not competent to handle that. So then it goes to the International Bureau as receiving office in Geneva.
That's a little bit different. That's an additional fact that we didn't know about before.
Exactly.
Yeah.
That's
Yeah.
the additional fact.
Okay, so thank you for that clarification. So maybe that is what your colleague is referring to, and you don't have to tell him he was wrong. He'll like that, right? Nobody likes to be wrong. Any other questions? Now, I know I'm at my time point, so I'll be glad to, I'll let you read the slides for the patent owner claim scope statement. There's only a few of them, but I'm glad to take any further questions you might have in lieu of walking through the slides. To me, that's more important. You get your questions answered. You can always read the material online. Is there any further questions? Oh, I think there might be one final question back here. And I'll be sticking around, so you can approach me one-on-one. And those on the web audience are welcome to email me a question. My email address is on the slides. Yes, sir.
If I were to file a continuation application today and submit the oath or declaration from the parent application, which was filed before September 16, could I expect to receive a notice of missing parts, or
Yes.
simply something from the examiner saying I have a defective declaration, I need to submit a supplemental declaration?
So I don't know the exact nature of the notice you're going to get, whether it's a notice of a non-compliant declaration or you're going to get missing parts, because we're just not going to treat the declaration as being filed because it's not compliant. But you cannot use that old declaration from the parent in the child application unless, for some reason, that declaration just happens to have the statements required by the AIA, which is doubtful. So more than likely, you're going to have to do one of two things. Have a new declaration executed by the inventors named in the child application, or take the declaration from the parent application, add the statements of original inventorship and authorization to it, have the inventors then attest to the truth of those statements, and re-execute again. The fact that you have the additional statements, the old statements that are no longer required, on there in addition to the new, won't cause the declaration to be bounced. You can have what I'll call superfluous information. What we are looking for is that you have the statements required by the AIA in that continuation that was filed after September 16. So more than likely, there's some work on your part to get a remedy for your situation. Easiest is just have a new oath or deck executed. Any other questions? No? Well, thank you very much for your attention. I'll be sticking around. I'm happy to chat one-on-one after the fact.